Welcome to Crime in Court. This is the 1996 Menendez brothers trial. We're reading through the transcript because unfortunately we don't have video. We've streamed through the 1993 trial, which ended in a mistrial. So here we are reading through the second trial and trying to compare and contrast what's different and how different the prosecution is versus the first one. This time around, they were prepared for the, if you want to call it the abuse excuse, as it was dubbed in the 90s. They were prepared for this because the first trial. They did not, they were not prepared for that the first time around. They were totally prepared to rebut it. They never did. In fact, they never did contest the abuse. All they did, I mean, they did call the brothers liars constantly, but they never actually, I mean, it's uncontested that the abuse occurred at this point. But yet, here we are in 2025, and the DA of our LA County District, who's also overseeing the possibility of the brothers getting out, has the mindset of the 90s that this abuse likely didn't happen and there's not enough evidence, which just baffles my mind because this case has the most evidence of SA and CA in like many cases, the majority of cases about this topic. This case has some of the most evidence. And for a prosecutor to say that is just insane. But as I'm speaking about Nathan Hochman, as I'm recording this, it is Monday, the 10th of March, but same day, Monday the 10th, there will be later today, there's going to be a press conference, an announcement coming from the DA's office, Nathan Hochman. He's going to have some new announcement. I don't know if this has to do with possibly what maybe he's going to say what his recommendations are for resentencing, and he's going to say, I fully support them getting out. I don't, it hasn't been his approach so far in the media, but let's see, let's hope. As I'm recording this, it's already happened, obviously, so we don't, I don't know what happens, but you guys do. So I will also be covering that in a separate video on my channel in case you didn't see it. So, all right, let's get started. We are on part 11 of the trial. Please hit that like button before I forget. So, part 11 of the state's case. And if you recall, we have a Google spreadsheet that everybody can look off of to see where we're at in trial. We've got, first off, Gil Garcetti is the DA, Carol Nahara is the deputy DA, David Kahn is another deputy DA, and they are, these two, Carol and David, are really the ones presiding the case. We don't really hear from Gil Garcetti. Same with Lyle. So if you recall, in the first trial, there were two separate juries, two separate sets of defense attorneys. In this trial, we have one jury, but still two separate sets of defense attorneys. And for Lyle Menendez, we have Michael Judge, who we have yet to hear from, and we're on week 2, almost week 3 here. And Charles Gessler and Terry Towery are the two the public defenders that are actually deputy public defenders who are actually the ones really presiding over the case. Then we have for Erik Menendez, Leslie Abramson, who is a repeat attorney from Trial 1. She's the only repeat attorney from Trial 1. The prosecution got all new prosecutors in this case. And the only returning attorney, Lyle's attorneys did not return, but Leslie Abramson stuck with Erik Menendez, and she brought on a co-counsel named Barry Levin. The judge presiding over this trial is the same judge from Trial 1, and his bias has been showing, in my opinion, in this case. He does, he throws the defense bones many times. So I'm not going to say that he's like completely corrupt and always sides with the prosecution because he doesn't. But there are important matters, important things, important evidence about this case that he mostly sides with the prosecution about letting it come in or, whatever. So there are ways in which he rules about important key elements of this case where it really does prejudice the defense in a lot of ways. Just as a reminder, the dates of this trial, we began in October of 95 and it ended in April of 96. So we do have a long ways to go still. We are on October 20th, and we're going to go over Howard Witkin's testimony. He is the IT consultant. He was brought on to look for a new will. I believe he's the one that Lyle. There's like three different IT individuals, so I get them all confused. One Lyle brought on to look for the will, delete it, delete the file, make it look like he wasn't there. And then there were two other IT consultants that were brought on separately by the family members. So I think like one uncle or aunt hired one and then another one hired another. So they were just doing, I guess, their due diligence to really look for this new will, which has been dubbed the new will because obviously Jose had a current will, and that will was the one that he had conversations with Carlos Baralt about changing or taking the brothers out of the will. So this new will is supposedly, the one without the brothers. However, there isn't really much to the new will, as we will learn. Also, don't forget, you have the link to the 1996 trial transcripts. Why is this not linking? And it whoops. And then it goes to an October folder, which you will have access to all these October. I've even uploaded a few extra days in there. So we've got, I think, 3 weeks worth of testimony in here. And we are going to be on, like I said, October 20th, right? I just want to double check that I'm correct. Yes, October 20th, 1995. All right. And he's already been called up to the stand and sworn in. Ms. Nahara will be doing the questioning. This is direct examination beginning. Mr. Witkin, can you tell the jury what your occupation is? Yes, I'm a computer consultant. And were you a computer consultant back in August of 1989? Yes, ma'am. And back in August of 1989, did you own a company called Leviathan Development? It was a partnership, partial owner. And what is Leviathan Development? We were a network system integrator. We do personal computer network and personal computer system consulting, hardware and software design, installation, service, support, emergency troubleshooting. When you say emergency troubleshooting, can you kind of, in layman's language, just kind of tell the jury what emergency troubleshooting is? As a lot of people are probably aware, PC hardware and a software doesn't always work the way you anticipate it will. It's not always as easy to use as people hope. What our individuals will call what okay, so individuals will call us. They have a problem with the computer system, hard or software not working, things they need installed, things that they can get to operate, documents they can't find, any sort of difficulty in using the computer system. They'll call us and we will send an engineer out to resolve the problem, fix the system, do whatever is necessary to make the computer productive again. And when you say emergency engineers, what are you talking about? The more dependent you are on a piece of information, the more quickly you need it, we promise immediate response. I mean, depending on the type of client and the type of, some of our support plans will promise 45-minute response, but if you need it fixed now, we have dispatch engineers available to fix it now. Okay. Now, back on August 31st of 1989, taking you back there to about 1:30 in the afternoon, were you in your car in the city of Beverly Hills? Yes, ma'am. And what time did you receive some kind of message? Or at that time, did you receive some kind of message? Yes, ma'am. Could you tell the jury how you got this message? From my pager. Pagers, again, this comes up. They were like these little devices, and you could send a you would type in a number for all you younger folks who aren't familiar. You would dial their pager number in the phone, and then after the beep, you would like leave your phone number. Sometimes there were codes like one 143 meant I love you and like stupid stuff like that. But you would send that, and then the person wearing the pager, they have this little device, the little beep goes off, and it says, "Oh, I have to call back so and so's number." So this is what we had long before cell phones, and this is how we communicated. So he got a page. And what did you do? I received a page from my office and a phone number. From the code number, I could tell it was a high priority call. 911 would be after the number. So you could type in your codes like 911. So I took my car phone and called my office to see what was up, and I was told there was a potential number in Beverly Hills that needed our services. Was this referred to as an emergency call? Yes, ma'am. Why was it an emergency? Ms. Towery, objection beyond the personal knowledge of the witness. The court sustains that. Again, could we have the date when this happened? Ms. Nahara says August 31st, 1989. The court says, was that your understanding of the date? The witness says, yes, Your Honor. I'm sorry. The court says, okay. Ms. Nahara says, now, you said you received a call from the dispatcher and you called them back. Is that right? Yes, ma'am. And after you received this information, what did you do with it? I took my dispatcher explained to me what the basic nature of the call was. I took down a name, the name and the phone number, and called the person back, potential customer back. And do you remember as you sit there today who you called back? Yes, ma'am. And who was that? It was Lyle Menendez. And did you call Lyle Menendez? Yes, ma'am. What happened? Did you have a conversation with someone who answered the phone and identified himself as Lyle Menendez? Yes, ma'am. What was the nature of the conversation? He reiterated what I had been told by my dispatcher that he had a computer system in his home, that on that computer system were certain files that had been lost and were unrecoverable, that he was getting on a plane and leaving California in a couple of hours. He desperately needed to have those files recovered. Could I please come immediately to his house and recover that information for him? And is this what you refer to as an emergency call? Yes, ma'am. Your understanding was you were to look for lost files. Is that right? Yes, ma'am. And after you received this information, what did you do? I told him that I was around the corner conveniently close, and I'd be over in a few minutes. And I proceeded to drive to the address that was given, to 722 North Elm Street, I believe. And how long did you take from the time that you made the call and spoke to Lyle Menendez to the time that you got to 722 North Elm? In the nature of 5 to 10 minutes, my best estimate. That's pretty emergency service. I didn't know that there were people that could just come to your house within 10 minutes and start recovering stuff on your computer. Does that even happen today? I don't think so. But back in the 90s, we had that. So that's pretty cool. All right. In the nature of 5 minutes, 5 to 10 minutes. Now, when you got to 722 North Elm, what happened? I parked my car on the opposite side of the street, grabbed my tools, and got out of the car, crossed the street to the gates, where I asked there were Bel Air Patrol or private security patrol guards that were on the driveway and beyond the gate, and I told them who I was and told them that I was there to see. Actually, what I said was Lyle Menendez because I had taken the name down incorrectly. Or Lyle Mendez, sorry, Lyle Mendez, because he wrote the name down incorrectly. What happened after you told them you needed to look for Lyle Menendez? They corrected me on the name and told me to wait just a minute. I don't remember if someone walked into the house or they buzzed into the house. But Mr. Menendez came out immediately within a minute or so, and and he they let me in, and he came out, shook my hand, and introduced himself and took me into the house. So approximately how long were you waiting before the defendant appeared to take you in? Less than a minute. So less than a minute after you arrived at the house, the defendant came out and greeted you. Yes, ma'am. And by the defendant, though the person that you're referring to as Lyle Menendez, do you recognize him in court as being identified as the defendant, Lyle Menendez? Yes, ma'am. Now, after he introduced himself and you went into the house, what was the first thing that happened? He brought me into the house and upstairs to a bedroom. Upstairs was a bedroom with the computer. Showed me where the computer system was. Again, reiterated that it was that he needed those files recovered, and I sat down and he explained to me that what he was looking for. He explained to me what he was looking for, and I began to attempt to recover the files. Okay, you said he told you that he needed the files recovered. What exactly did he tell you about what you needed to do? What he told me I needed to do is he had lost on the computer, as I recall now, it was 4 files. Any information on a file called Lyle, one named Erik, one named Will, and one called Menendez. And I and I please try to find those files. He says, and could I please try to find those files on the computer for him? You said, as of now, you remember it's 4 files. Sometime in the past, did you think of it was a different number of files? Sorry, did you think it was a different number of files? I think I've misspoke in my original police report and only cited it as 3, but I remember it as first names and a last name. And you testified previously in this matter, is that right? Yes, ma'am. So he's said in the past that it was only 3, and now he's changing his testimony in, years later, saying that it was 4. So what changed? Why, is his memory different? Is it better now than it was back then? I doubt so. I doubt it, but that's why they always ask that question. Is your memory now better than it is now, or back then than it is now? And usually they have to admit, yeah. All right, so I think I've misspoke, and it was the last name, blah blah blah. And you testified previously in this matter, yes. And at that time, you recall that it was 4 files. Yes, ma'am. And you said that, well, aside, did the defendant, Erik Menendez, tell you, Ms. Amerson says, object to the question, Erik wasn't there, sustained. Excuse me, my apologies. With regards to what the defendant, Lyle Menendez, told you, he said he wanted 4 files. Did he say he wanted anything else, or did he say anything else in the conversation? Initially, he just and again emphasized the importance of the information and could I please do whatever I could to recover those 4 individual files that they were very important to him to have. The court says, ladies and gentlemen, all of the statements attributed to Lyle Menendez by the witness are admitted only in the case of People versus Lyle Menendez and should be used by you only as to the part of the case where you evaluate the case involving Lyle Menendez. I'm talking now about the statements made by Lyle Menendez to this witness that he tells you about. The actual conduct of the witness, what he saw and what he did, what he saw on the computer is admissible and received as to both defendants, but the words uttered by Lyle Menendez will be received only and used by you only to determine the case of People versus Lyle Menendez. You may proceed. Ms. Harris says, thank you, Your Honor. Now, after the defendant, Lyle Menendez, requested that you find this information and its importance, did you go to work on trying to find the information? Yes, ma'am. And at that time, did the defendant, Lyle Menendez, what did he do, if anything? For part of the time, he stood behind me and watched. He left the room, came back, seemed fairly impatient to know whether or not I would. Miss Towery says, objection, motion to strike. That's a conclusion on the part of the witness. The court says, well, the answer will remain as far as up to the point appear to be fairly impatient. The rest of it is stricken as a conclusion. The witness says, sorry, Your Honor. The court says, that's okay. Your next question, please. Ms. Nahara says, certainly. So, what exactly did you see the defendant, Lyle Menendez, do while you were working on the computer? While I was working on the computer, he was talking on the phone for part of the time, but he would stand behind me and ask what I was doing and how I was doing, and would leave the room, come back and ask me if I had any luck, leave the room for another few minutes, and come back and ask if I was having any success. I don't remember exactly how many times he came in and out, but he was in and out and kind of hovering. Ms. Towery says, objection, motion to strike, conclusion on the part of the witness. Overruled, says the court. Ms. Nahara says, for about how long did it take you to search for the items that he asked you to search for while he was doing in and out of and hovering, or while he was going in and out and hovering? The initial search, where I was searching just for the files itself, was just 5 minutes. 7 minutes was not particularly long because searching for the physical files, there wasn't all that much time. Now, at some point, after you were searching for these files, did you come to some conclusion about them? Yes, ma'am. And what was that? I found that there were, in fact, 3 files. I believe it was 3 files. There were several files that had those specific names, at least Lyle, Erik, and Will, and I showed him the contents of those files. And did you have a conversation with the defendant, Lyle Menendez, at that time after you found the 3 files? Yes, ma'am. And what did you and the defendant, Lyle Menendez, discuss? That the information that I found in those 3 files was not the information that he was looking for. Those 3 files, I explained to him, those 3 files contained merely the contents of index directory that apparently someone had printed a subdirectory, a portion of a listing of an index of the computer into those 3 files. And we discussed that that was not what he was looking for, and he asked me if it was possible to search for the information. I explained to him the information might exist on the disks elsewhere, no longer a file, if the file had been erased by accident or on purpose. And he asked me to please try to search the rest of the disk to see if I could find any information. So at this point, I'm just going to stop him there, do a little highlight so I remember where I ended it. But, so he's coming into this. First of all, I want to make a point. If these files did contain a will, would Lyle be so um what's the word? Would he anticipate them so anxiously or whatever whatever words you want to describe him? Um would he be trying to find them is what I'm asking. Would he if he was concerned that there were this other will on the computer, would he be wanting to hire other people to find them so badly? Is it in his best interest to find a will that has him cut out of it? Is what I'm trying to say. Why would he try so hard to get this supposed will if it doesn't help him? And obviously, this person's going to be a witness, if Erik and Lyle were ever to have gotten caught. So, he's leaving a paper trail and all that. So it's not like he's being very um, secretive about doing this. So that's one point that I was going to make. The second point I was going to make is that by the time this individual, Howard Witkin, comes in, starts looking at the computer, this is 10 days after the parents have died. And he, at this point, he's looking for these files. He's already he's found that these files have already been wiped or moved, might exist on a disk, whatever. They're not available on the computer already. Like he's already found that these documents are not available. He's found some information about them where he can relay that, there was only 50 some characters in one of the documents, so that does not make a full length will, 50 characters. So he's already proving that there wasn't a new will. So he proves for the defense that there wasn't a will, I think. Um, but he is called as a state witness. So make sense. I don't know. All right, moving on. He says, so rather than searching for files that by those names, I then searched for those actual words anywhere on the disk, whether it was a name of a file or in a file and just on the disk, but not actually in any file. Now, going back to the first time you spoke to the defendant, Lyle Menendez, you said the file had either been erased by accident or on purpose. Can you explain to the jury what you mean by that? I'm not sure how much detail that you want. Did you come to the conclusion that the files had been erased either by accident or on purpose? Ms. Towery says, objection misstates the testimony. He didn't say the files had been erased. The court says he did say that the files themselves had been erased, is what he said. Perhaps you can clarify. You said there were files that contained something else. Perhaps you can describe what they contained. The witness says, may I speak narratively? The court says yes. Thank you. The 3 files that I found, the ones named Lyle, Erik, and Will, possess, if you look at the actual contents of the file, what they possess was just a printout, essentially, of the index of a small part of that disk. That they didn't actually contain any real data. They weren't a letter. They weren't a spreadsheet. It wasn't like a Word document. It was data about the Word document, if that makes sense. So, like the Word document itself, gone. But the information, the data about that Word document, you could still glean some information from the remaining data, if that makes sense. So they weren't a spreadsheet and they weren't some sort of document. They were just a printout, an index. So it was the index of what had been contained in the computer at one time. What I explained was that if a letter had existed called Lyle and it had been written over by this, what I called previously a dump file, a directory file, the information which had been in the original letter might still exist on the disk, but it would no longer be in the file called Lyle because the file called Lyle had been replaced by the copy of an index, this copy of a directory. So I suggested that I could look elsewhere on the disk and see if there were any other files that might contain the information, either the words Lyle or Erik or Will, but that were not necessarily filed with those specific names. Is that clear? Ms. Nahara says, just so I can clarify one part of what you are telling us. You said that that the files that had been found had been written over by will be written over. Is that correct? If there had been previously a file, if there had previously been a file called Lyle, which is at that point what I had been informed, I was asked to please look for an important document called Lyle. If that document had existed, it no longer existed. It had been replaced or written over by this little directory entry called Lyle, but the information that had previously been in that document previously still existed elsewhere on the disk. Now, when you told the defendant, Lyle Menendez, that this information that you couldn't find in the files might exist elsewhere in the disk, did he have a conversation with you about what you should do? Yes, ma'am. And did he tell you to do something? Yes, ma'am. What did he tell you to do? To make my best effort to try to recover the information wherever I could find it on the disk. So he didn't say delete it. He said recover it. Big difference here. And the prosecution has always tried to make it seem like he's made it like he's trying to cover his tracks or something, like trying to cover it up. And did he say anything else about this? in part of that explicit 3 sentence conversation, not that I recall, just to proceed and do whatever I could to recover it. And what did he do as a result of this conversation? I took another software tool that could actually search through all of the characters of the disk, through all of the files and all of the non file areas, basically look through all of the pages and disk and search to see if anywhere in that disk existed the word Lyle and the word Erik, or the word Will or the word Menendez out of these files. And after you did all of this with the computer, what did you discover? That nowhere else on the disk did those words exist in any other document or in any previously erased document that, or at least that was still sitting empty, unused, unallocated space that hadn't been written over by something else. So it had not been written over by something else. Now, after you determined that nowhere else in the disk was this information, did you have another conversation with the defendant Lyle Menendez? Yes, ma'am. And did you tell him that you couldn't find any of this information? Yes, ma'am. When you found this out, when you found this out, did the defendant Lyle Menendez tell you anything? Yes, ma'am. What did he tell you? That was in fact very good. In fact, he was happy that the information was not on the disk. The fact that he was not trying in reality to recover it, but in fact was really trying to make sure that it was not in fact there. Okay. Well, that may be your opinion. What did he exactly say? I can't wait to be scrutinized, this comment by the defense attorneys. Now, after he told you that, did you and the defendant have any other conversation? Yes, ma'am. What else was said? Mr. Menendez then explained to me that they were selling the computer, that the information that he had asked me to look for, that the computer contained was sensitive family financial information, and if this data, and that his real purpose was that in selling the computer, they did not want that information going with the computer. They wanted to make sure that it was gone, and would it be possible for me, even though I couldn't find it, to make sure that no one else could find it? Could I erase it in such a way that the information would become unrecoverable, not only to me, but also to someone who might be better equipped than I was? And when he asked you to do this, how did you respond? I told him that yes, in fact, I could completely erase the disk so that none of that information was on it, and in fact, there were standard programs that were designed essentially to declassify disks, to take and permanently destroy, erase, or eradicate any information that might have existed on that disk. After you told him you could permanently destroy any information on that disk, did he ask you to do anything? Yes, ma'am. And what did he ask you to do? He asked me to go ahead and do it. When he asked you to go ahead and permanently destroy anything on the disk, you do that? Yes, ma'am, I did. And when you finished performing that task, did you have another conversation with the defendant, Lyle Menendez? Yes, ma'am. And what was the nature of that conversation? He asked me if it would be possible for me to make it look as if the disk had not, in fact, been erased. That making it looked like it was erased would lead someone to wonder what was there. Could I, in fact, hide the fact that it had been erased? Could I make it look like I had never been there? And first of all, how long had you had been doing this up until 1989? We started Leviathan in 1984. Previous to that, I worked for IBM for technical support. Previous to that, I had done database programming. Previously to that, I had done video game design since about 1982 to 83, give or take. And the time that you had been doing these services for Leviathan from 81, it should have been 82, had you ever, Ms. Towery, objection, irrelevant, Ms. Towery, or Ms. Nahara says, had anyone ever asked you to make it look like a disk hadn't been erased? The court says objection sustained. Okay. That was like too late. He said he sustained the objection later. Then the question, Ms. Nahara says, did this seem like an unusual request? Objection irrelevant, sustained. Ms. Nahara says, how did you react to making it look like no one had ever erased this disc? Same objection, Ms. Towery says. The court says, ask him what did he do? Like, the judge has to tell the prosecutor what kind of questions she's allowed to ask. Ms. Nahara says, what did you do? I told him that I could. I told him that I could do it if he had the original programs that he had been on the disk, not the data and documents that he read, but the original store purchase software. So, like a Microsoft or whatever, that I could restore that software, but I put it on the machine and it would no longer be obvious that it had been erased. The court says, let me say this. There's a question from one juror asking whether the jurors could ask questions. If any juror had some questions you wanted to ask, the best and only way you really can do this is to put it in writing and give it to the bailiff and give it to me, and I'll discuss it, show it to the lawyers. The fact that you might want to have a question asked doesn't necessarily mean the question will be asked, because some questions, for one reason or another, just can't be asked. The lawyers normally ask the questions. Occasionally, I'll ask something to clarify something that's ongoing. Principally, the lawyers do the questioning and they know where they're going and what the issues are. If you have a particular question, I'll give it to the lawyers and discuss it with them. It could very well be what you're asking is an improper question and can't be asked and won't be asked. It won't be the lawyer's fault if that occurs. It will be just because, for whatever reason, the particular question can't be asked. Sometimes you put the lawyers in an awkward situation because you're asking a question that can't be asked, and they realize it and discuss it with me. But certainly, if you want to ask a question, you can put it in writing and give it to the bailiff, and we'll review it. Okay, you may proceed. Ms. Nahara says, thank you, Your Honor. Now, Mr. Witkin, when asked to make it look like the computer had never been erased, what all is involved with regards to making this computer look like it hadn't been erased? Ms. Towery says, objection, vague. The court says, do you understand the question? The witness says, is she asking me what did I do, or what are the possible ways that it could have been done? Why don't you wait for her to clarify? Ms. Nahara says, I sure will. What did you have to go through to make it look like the computer had never been erased in the first place? I reformatted the hard drive using an old version of DOS that they had in a box there, rather than a new version, to try to make it look like it had been formatted earlier, reinstalled the older version of DOS, changed the dates, recreated a subdirectory, installed a few spreadsheet programs, changed the date, reinstalled another one of the programs, and basically went through and recreated each of the program files on the disk in its own subdirectory, kind of mimicking what it might have looked like if they had been installed over the course of time previously. So what did you do? Or so what you did was kind of put a fake grouping of information in there. Ms. Towery says, misstates the testimony, sustained. Ms. Nahara says, how would you describe it in layman's terms? Nothing fake. I just put all the programs back on, but not time-stamped all simultaneously. So when you say not time-stamped, how does this affect everything? Objection, vague. Do you understand the question? The court says, I think so, says the witness. The court says, okay. Witness says, if I can have it reread to me, though. The court says, okay, let's have it repeated. Ms. Nahara says, I can actually re-ask it. When you say you put back in all the programs, but they're not time-stamped, what I'm asking you is how. How is this different from the program that was erased so that now it won't look like it's erased, is what I'm asking you. If the disk were empty, with nothing on it, it clearly would have been clearly erased. If all the programs had been installed, when you write a program onto the DOS disk, it records a time. The time isn't absolute in an old computer like this because it doesn't have a running clock, but it is relative to the time that the computer was last turned on. So the date might be in 1980. The date itself isn't relevant, but the progress from whatever time it was turned on is relevant. So rather than having created exactly the same time, I changed the dates between each program that I loaded. All right, now after you had erased this computer and made it look as though it had never been erased, did you talk to the defendant, Lyle Menendez? Yes, ma'am. Did you tell him what you had done? Yes, ma'am. And did he respond to that? Or how did he respond to that? Favorably. And when you say favorably, can you describe what happened? He thanked me. This is basically, we're done. He thanked me for my time, asked me how much it would cost. I gave him a price. Ms. Nahara says, Your Honor, I have an exhibit here that was previously marked number 63. I'd like to have it marked 108 for this trial. The court says 108. Ms. Nahara says, Thank you, Your Honor. If I may approach. Ms. Towery says, Could I look at it? Ms. Nahara says, Now, sir, showing you what's been marked People 63. It was 108. What's been marked as 108 and ask you to take a look at that picture. Yes, ma'am. And tell me if you recognize the computer in that picture. Yes, ma'am. Does that appear to be the computer that you worked on in the Menendez home? It appears to be yes. Now, it was at some point, well, when you were done erasing the computer and you were done making it so it didn't appear to have been erased, you said you had a discussion with the defendant, Lyle Menendez, about getting paid. Is that right? Yes, ma'am. And did you tell him how much it would cost for the service you had just extended to him? Yes, ma'am. And how much was that? I believe $150. And when you explained to him how much it would cost, what happened? Did you have a conversation with him? Yes, ma'am. And what was said? He wrote me a check. That's not what was said or a conversation. I don't know how much conversation that really entailed. Exactly. And at that time, you said that the company was called Leviathan Development. Is that right? Yes, ma'am. And did he write the clerk to Leviathan Development? Or let's just say check. Did he write the check to Leviathan Development? No, ma'am. Who did he write the check to? Cash. Ms. Nahara says, Your Honor, two exhibits that have been previously marked, the first being exhibit number 66. I'd like the excuse me, I'd like it marked 109 for identification. The court says yes. Ms. Nahara says, and Your Honor, I have another exhibit that has been previously marked as 67. I'd like to mark it for 110 for identification. He says yes. Okay, thank you, Your Honor. I believe counsel are familiar with these. All right. Showing you what's been marked now as exhibit 109 for identification. Will you take a look at that and tell me if you recognize it? Yes, ma'am. Now, what is that? It's a check drawn to the amount of J.E. Menendez made out to cash for $150, as well as a slip from my bank that is a processing slip saying that the check was returned and did not clear. Did not clear. Is that the check that the defendant, Lyle Menendez, wrote to you for cash for the services you had rendered? Yes, ma'am. And is it drawn on the account of J.E. Menendez and M.L. Menendez? Yes, ma'am. So that would be the parents, obviously, the parents' account. So there was no cash in it? That's interesting. Yes, ma'am. And showing you what has been marked as People's 110 for identification, would you take a look at that and tell me if that is a blow up of a check that you've just identified, the front portion? Yes, ma'am, it appears to be. Now, after you provided these services, did you present the defendant with a receipt for these services? Yes, ma'am. And how did that come about? While he was writing, after I told him the amount, while he was writing the check, I went back to my toolkit and took out what we call a service authorization, which is one of our worksheets. And I filled out the worksheet, tore off the yellow copy, which is the customer copy, and brought it back. He gave me the check and I set down the receipt. He left the room and I set down the receipt. You said he gave you the check, is that right? Yes, ma'am. Now, you had the receipt. Did you have the receipt at the time that he gave you the check? I had not written it out yet. So, when he gave you the check, what did you do in regards to the receipt? I wrote out the receipt because I think I stood either at the television or I stood against some piece of furniture and I wrote out the receipt, tore out the yellow copy, and set the receipt down. And where was the defendant, Lyle Menendez, when you were writing out this receipt? He had left the room. He was still on the telephone. So he was not present when you wrote out the receipt? Not while I wrote it out. You said that then, you said that you then took it and put it, where did you put it? I believe on the television, whatever piece of furniture that I was standing at writing. I had torn it out and set it down. And was the defendant, Lyle Menendez, present when you left it in the room? I don't believe so because I believe I walked to the door and he met me in the hallway and took me downstairs. So you had the check and left the receipt there, is that right? Yes, ma'am. Was he ever present when you were working on that receipt? I don't recall. I don't know. So you don't recall seeing him there while you were writing out the receipt. He was certainly there when he handed me the check and after I had taken the receipt out of my tool bag, but exactly when he walked out of the room and walked back to the room, I don't recall exactly. He may not have been. And you left the receipt sitting on top of the I set it down on the television. I don't remember exactly which piece of furniture I was leaning against or writing on. Did you call attention to it or did you call attention to it as you were walking out to the defendant? Did you call attention to the receipt? Probably. I don't recall exactly. So when you say probably, do you recall? No, ma'am. All you recall is you left it there. Yes, ma'am. Ms. Nahara says, Your Honor, I have two items. One I would like marked, excuse me, Your Honor, it's already been marked, People's 80. If I may approach, the court says yes. Ms. Nahara says, showing you what has been marked as Exhibit 80, would you look at that and tell me if you recognize it? Yes, ma'am. And could you tell the jury what it is that you're holding right there? It is a yellow copy of one of our service authorizations, and if you'll forgive me for correcting my previous testimony or supplementing it, please do. It is it is what? What is that word? Initiated? It is in a I don't know what that word is. I think it is a misspelling. So I would change my I don't recall. I assumed that yes, I did in fact show it to him because he does have it installed? Initiated? I don't know what they're trying to say here. I don't know. That's not a word, is it? Okay, I'm really confused. I need to look it up because this is going to bother me. I'm a dummy. It's the word initial, but it's initial, like the past tense of initialed. I don't know why that reading in all caps is hard. I want to say, I wish these weren't in all caps because it does kind of throw you off on your game sometimes. So, apologies. Moving on. All right, it is initialed. So, I would change my I don't recall. I assumed that yes, I did, in fact, show it to him because he does have it initialed. So, he initialed it with, LM or whatever. All right, so because you have the initial, and after it was initialed, and they keep spelling it multiple ways too. I don't know. Whatever. Okay, moving on. After it was initialed, do you recall leaving it on the television or leaving it on a piece of furniture? Yes, ma'am. Do you recall when it was initialed? No, ma'am. And showing you, Your Honor, I have an exhibit. I believe counsel has already seen it, which I'd like marked as People's. The court says 111. 111. It was previously 65. And showing you exhibit number 111, would you take a look at that and tell me if you recognize it? Yes, ma'am. And what is that? Looks like a Xeroxed blow up of the yellow document we were just looking at. And the yellow document is the receipt that you left? The service authorization. Yes, ma'am. Now, when you were through with this transaction, did you leave the house? No, he's still there. Yes, ma'am. Some of these questions are just so ridiculous. And had you known at that time on August the 31st of 1989, were you aware that there had been a homicide at the Menendez home? No, ma'am. And were you aware of anything that had been, no, ma'am, not at all, talked about or been any publicity about? No, ma'am. Sometime after this transaction occurred, did you become aware that there had been a homicide at the Menendez home? Objection irrelevant, says Ms. Towery. The court sustains that. Ms. Nahara says, at some point, did you become aware that you had information that might be pertinent to this case? Ms. Towery says, objection irrelevant, overruled. Yes, ma'am, says the witness. Ms. Nahara says, and how did you become aware of this? Ms. Towery says, same objection. The court says, sustained. Are you asking when did he first speak with anybody about it? Is that what you're getting at? Ms. Nahara says, it's foundational to that. The court says, let's get to that. Ms. Nahara says, when did you first make any attempt to contact the police about this event? I believe my first phone call was after objection, same objection, irrelevant, overruled. My first phone call to the police was after the check came back from the bank. The check had a refer to maker stamp on it. The bank returned it to us, and when I called the bank to ask what a refer to maker stamp meant, I was told the person whose account it had been drawn on had been there had been a homicide and they were no longer alive. And that next morning, I saw an article in the paper that mentioned the Menendez homicide, realized they were the same, and I anonymously called the police department. Now, when you anonymously called the police department, did you talk to somebody there? Yes, ma'am. And did you leave some information with the person that you spoke to? Yes, ma'am. And what was the information that you left? Objection, irrelevant, hearsay. Overruled. It's not offered for the truth, just to reflect what the witness did. Ms. Abramson says, I would object that that's not relevant either. The court says, not really what? Ms. Abramson says that that's not what he did isn't relevant at this point in the time either. And the court overrules that, of course. The witness says, could I have the question read back? The court says, you talked to someone anonymously on the phone. The question is, what did you say? Ms. Nahara says, what did you tell them? Sorry, that was the court that was asking that. You talked to someone anonymously on the phone. The question is, what did you say? Ms. Nahara says, or sorry, the answer is that there was someone named Lyle who had made efforts to have evidence destroyed in the case. Objection, motion to strike. Yeah, you better strike that crap. Conclusion on the part of the witness and irrelevant. The court says, all right, objection is sustained and the jury is admonished to disregard it. Could we have a time frame as to when you called the police? So this guy already is assuming that, Erik or Lyle is nefarious, doing nefarious things, and that's why he's calling the police and letting them know. All right, so he's already kind of biased. Could we have a time frame as to when you call the police? 5th, 6th, 7th of September, somewhere in that range. Court says, after this anonymous call, did you speak with the police again? Yes. How long after that? December 5th. The court says, December the 5th? Give or take. Nothing between September and December? No, sir. That's interesting. Ms. Nahara says, around September of 1989, so they waited months to talk to him. And he supposedly had some information that could help, you know, show some guilt towards their defendant, and they didn't even want to talk to him. Ms. Nahara says, around September of 89, after you made the first anonymous phone call to the police, did you do something with the check? Yes, ma'am. What did you do with it? Gave it to my lawyer and told him to hang on to it, that it might be, Ms. Abramson says, object to anything he said, Your Honor, as non-responsive and hearsay sustained. When you called the police and left this anonymous information, did you talk to a police officer? Object beyond his personal knowledge unless he had a video phone. Sustained. Did you call a police station? Yes, ma'am. Who did you call or what? Beverly Hills Police Department. And did the person who picked up the line identify him or herself? Objection irrelevant, 352. Okay, you're talking about when now, says the court. Ms. Nahara says, in September of 1989, when you made the anonymous phone call to the police and you called the Beverly Hills Police Department and someone answered the phone. Is that right? Yes, ma'am. And as you sit there right now, do you recall who you spoke to? Not a clue. Did you give them some information concerning your transaction with the defendant, Lyle Menendez? No, ma'am. What did you tell them? Objection, Your Honor, we've already been through this. Objection sustained. We've gone from September to December. In December, who did you speak with? Do you remember? The witness says, December, I spoke, I believe, to Detective Zoller. Objection, says the court. What? Okay. By Ms. Nahara, she says, now in December, did you contact Detective Zoller or did Detective Zoller contact you? I contacted him. And did you have a conversation with Detective Zoller about what had happened? Ms. Abramson says, objection, Your Honor, calls for hearsay by implication and isn't irrelevant. The court says, overruled, you can answer that yes or no. The witness says, yes. Ms. Nahara says, and did you give him information about what you knew about this case? Yes, ma'am. Objection, Your Honor, calls for a conclusion. The witness says, I'm sorry. Speculation. Overruled, the answer will stand. And do you know if Detective Zoller did anything as a result of the information that you gave him? Objection, Your Honor. How could he know that? Unless he was with him? Objection sustained. Calls for speculation is the legal objection. Ms. Amerson says, "Thank you, Your Honor." Ms. Nahara says, "You gave this information to Detective Zoller on December 5th, 1989. Is that right?" I believe that's the date. And do you know what date it was that Detective Zoller retrieved those documents from the house? Objection calls for speculation on the part of the witness. Sustained. How would he know that? Do you know whether or not they were retrieved as a result of any information you provided to the police? Objection, not within the personal knowledge of the witness. Sustained. This is very improper trying to get this in like, well, it's coming to, you, um, I don't know. The way that they're trying to ask it, I guess, is improper. I'll reserve my thoughts. All right, so Ms. Nahara says, and at some point, did you turn the check over to the police? Yes, ma'am. Ms. Nahara says, thank you. I have nothing further, Your Honor. We're going to begin cross-examination with Ms. Towery for Lyle's defense team. Thank you, Your Honor. Good afternoon, Mr. Witkin. Good afternoon, ma'am. You testified at the previous trial in this case, didn't you? Yes, ma'am. And the last time you testified, there were cameras in the courtroom, weren't there? Objection irrelevant. The court says it would seem to be. Objection sustained. Ms. Towery says, do you know if your testimony was televised at the last trial? Objection irrelevant. Sustained. How is that not relevant? It's his testimony. He testified. Oh, this is judge. Okay. Ms. Towery says, I'd like to make an offer, Your Honor. The court says, does it have to do with this witness's testimony or somebody else? No, another witness's testimony. The court says, overruled. You can answer the question. The witness says, the question is, do you know whether or not your testimony in the first trial was televised? The witness says, I don't know for certain. Ms. Towery says, do you remember seeing a camera in the courtroom when you were testifying the last time? Objection, irrelevant, overruled. Yes, ma'am. So you did see one. Is that correct? Yes, ma'am. And mercifully, that camera is not here now. Yes, ma'am, or no, ma'am, whichever way it works. She says, so you also testified before the grand jury in 1992, did you not? Yes, ma'am. And that's when you initially said, Ms. Abramson says, Your Honor, I can't hear counsel. Ms. Towery says, that's where you initially said that you were only asked to look for 3 file names. And then you remember that there was a 4th name as well, correct? At the grand jury. I believe that I initially said 3 in my police interview, and I believe I also said 3 in the grand jury. Each time I left out one name. That I believe it's Lyle, Erik, Will Menendez. And I believe one time, I'm not a professional at this, I believe one time I left Lyle out and one time I left Erik out. Kind of an equal opportunity, innocent misrecalculation. But he's leaving out the names of the children who are the suspected criminals. So you would think that he would not leave those out. That's weird. I don't buy this excuse of I remember there are 3, but then 4, a 4th name. That doesn't make sense to me. Especially, I mean, it just makes it seem less reliable, him as a witness. His credibility kind of goes out the window. Ms. Towery continues, perhaps one time you left Will out. Is that possible? I don't think so. Not at the grand jury you didn't? If you have it in writing, then I'll go with what's in writing, but I don't have my testimony in front of me. Did you review your grand jury testimony before you testified here today? I did reread it. So, grand jury or your testimony at the first trial. I was given a copy and reread my original police report and original grand jury testimony, my original testimony in the Lyle case. Apparently, there was an off the record discussion between the two, which ended up in the transcripts I was given. I read that and my testimony in the Erik case. That's all I reviewed before this. And because remember, the Lyle case and the Erik case, there were 2 separate cases. So he had to testify in front of different juries. So that's what he's talking about there. And who provided you with the testimony, if you can remember? I asked Detective Zoller if he could please give me a copy of the previous records. Why is he talking to the lead detective about it? And let's just see which file you leave out in your grand jury testimony. Reading from page 81. Ms. Nahir says that's okay. Ms. Towery continues. Okay, lines 22 through 26. Quote, he gave me 3 names, 3 file names, and said he was looking for a reference to the name Lyle, Erik, and Menendez. No Will. No Will. There is no reference to a will. This is telling, isn't it? Still going on with the quoted testimony. Question, did he mention anything about a will? Answer, no, he did not. What the? This is one of those what the F moments. There was no will. He wasn't looking for a will. But yet, that's the whole time the prosecution's been spinning the story that the word will was on the computer. So who's been who has a pattern of misrepresenting the evidence in this case? Is it the defense or is it the prosecution? I would say the prosecution has had quite a tendency to mislead with the evidence. And this would be one of those instances. That's been the narrative all along. There was a new will on the computer. The new will. There's no will. This guy testified in trial one, no will. It's crazy that we keep going with the prosecution story throughout time, isn't it? All right, moving on with the transcript. Ms. Towery says, does that refresh your recollection as to the grand jury testimony? Yes, ma'am. So that will, the word will, was one of the files that you left out at one point. Is that right? Yes, ma'am. Now, in your business, you get a lot of calls from people who feel that they have lost or erased files. Is that right? Yes, ma'am. And that's in part because a lot of people don't know how to work their computers. Is that a fair statement? Objection calls for speculation on the part of the witness. Overruled. He said, Ms. Towery says, sometimes when people, so it was overruled, but she didn't have him answer the question. She's going to re-ask it. Sometimes when people think that they have erased a lot of files, in fact, they're there all the time. Is that right? Yes, ma'am. And that's part of your job is to find it for them, correct? Yes, ma'am. Now, the computer that you saw at the Menendez home that day that you've identified in the photograph that you were shown, what kind of computer was that? I believe it was an IBM XT. And can you explain to the jury what an IBM XT is? Let me ask you a question. Maybe there's an easier way to do it. At that time in 1989, was an IBM XT a modern computer? No, ma'am. So this is already a relic that they're trying to work on here. And yeah, it's outdated at this time already. So it was kind of a dinosaur computer even then. Yes, ma'am. And one of the things that I'm glad they cleared that up because I wouldn't have known that until, because back we don't know the technology of what was going on back then. I don't remember anyways. All right, so and one of the things that was peculiar to an IBM XT computer at that time was that it had no clock, no internal clock that would continue to run when the computer was turned off. Isn't that correct? Yes, ma'am. Modern computers today will tell you when you turn them on what day it is and what time it is, assuming they're set correctly at some point. Is that correct? Generally. Okay, and that clock will continue to run from a battery while the computer is turned off, right? That's the way it's supposed to work. Okay, but the XT computer that you saw didn't have that clock and battery, isn't that right? It is possible to add a clock to an XT. I don't believe it had one, but I wouldn't swear to it. I don't believe it had a real time clock in it. And on the XT computer, most of the time they did not have that. Is that a fair statement? Exactly. So, because you were aware of that when you were working on the XT computer, sometimes or times wouldn't really mean anything when you saw a time on the computer screen. Is that a fair statement? As absolute time, no. As relative time, possibly. So, it's not accurate. The timestamps that he changed later on were not something that was of real significance. So, all right, an XT computer would be set when at the factory. If you purchased one, would it have a time set? Ms. Nahir says, I'm going to object as irrelevant. The court says, okay. The witness says, I believe it's Tuesday, February 1st, 1980 is the default date, or January 1st, 1980. Ms. Towery says, whenever you would buy an XT computer or obtain an XT computer that would exhibit the date, that would have been set on it originally, correct? Yes, ma'am. And the date, that would come up every time you turned the computer on, unless you changed the date, correct? Yes, ma'am. So now in fact, as you recall now, you were asked to retrieve 4 files from this XT computer at the Menendez home. Isn't that right? Yes, ma'am. Can you explain to the jury what a file is? The way The way a computer stores information, permanent storage. Forgive me, I'll give you a slightly extra background. The way a computer stores, which is on a hard drive, its magnetic surface that contains a series of ones and zeros. And that's inside the computer. It's inside the computer. You look at this computer and you see the two little black face plates. Behind the black face plates on the left is a little box yay big, a magnetic film sprayed over it, and the way that the computer stores information is it divides that surface into a number of what are called sectors, and those sectors into blocks, and each block can contain 512 bytes or 512 characters. So let me stop you there and explain what a byte is. Ms. Nahara says, I'm going to object as irrelevant. Overruled. Is he, I, now I want him to get this information out because it's good for the defense, but he's not admitted as an expert in IT. You know what I'm saying? Like he is a percipient witness, meaning he actually like witnessed, saw something with his own senses, something to the crime or something related, crime adjacent, something that can help with the investigation. So he's here testifying against Lyle, basically, and the defendants, but mostly Lyle, because that's who his interactions were with. But yet he's also testifying as a computer expert, but he's not admitted as an expert in the court of law. You have to be admitted as an expert to testify against or for these things. So I'm kind of confused as to how he's able to testify to this stuff. He seems like an expert, but I don't know. What's his background? We didn't even go into that. So it's a little I just find it odd that he's testifying as a expert as well as a lay witness. So the witness says a byte is the basic unit of information storage on a PC. It can either represent a letter, a number, a character, an instruction. It's 8 bytes. Think of it as 8 light switches that can be set to on or off. So it has value of 1 or 0, and between those 8, it gives you 256 combinations, and each combination, if it's a text document, represents a letter or number of characters. If it's a program, it represents an instruction, a command, a piece of command to the computer. If it's a graphic file, it's whether something is turned black or white or blue or a piece of a picture. Ms. Towery says, okay, that was very not helpful. I didn't understand any of that. I'm not a techie. I didn't get it. And I don't know how up to date any of that information is. I mean, at the time in 1996, it was certainly, suppose according to this guy, relevant, but I don't know. The witness says the file is a chain of these bytes. Ms. Towery says, let's stay with the byte for a minute. Okay. Let's say you have text that you're correlating with a byte. Yes. Is 1 byte approximately 1 character in text? Yes, ma'am. And now, I was asking you to explain what a file is. Can you continue with your explanation? So, a file is a group of bytes, a group of characters that are related to each other that usually start with one special character to say this is the beginning of a file. One special character saying this is the end of the relevant information that are all placed usually to start with a small file. They'll all be placed together on one block of a disk. If it's a bigger file, it may extend over multiple blocks, and then the second piece is there's usually an index or reference that goes which block this file starts on, and then the end of each block's reference of which block to find the next page, so to speak, in a file. So a file is a chain. It's a group of pages of bytes. That was not helpful. This guy's this guy should not be admitted as an expert because his explanations aren't great. Ms. Towery says, okay. He says, is the best I can explain It's the best I can try to explain it in English. I don't know if that was English, but I can try again. Miss Towery says, what I'm going to do, with the court's permission, I have some paper that maybe if we can make a chart for the jury to, it might be a little bit easier to describe this. Ms. Nahara says, I'm going to object as irrelevant. The court says overruled because he's confused too and he wants to understand. But no, because the prosecution, they live off of confusion for the jury because then the jury's like, well, I don't know what happened. So sure, he's guilty because they arrested him. That's usually how it works. Um, so the prosecution's just like, yeah, let the jury remain confused about this. Ms. Towery says, now can you see it? I'll manage. At the time that you did this work on the IBM computer, IBM XT computer, there were basically two types of computers in existence. There was an IBM and an Apple, right? Ms. Nahara says, object to anything not having to do with the computer is irrelevant. The court says, let's stick to the IBM. Ms. Towery says, I'm not going to go into the Apple other than it was much simpler to use at that time, Your Honor. And she continues on, is that a fair statement? The Apple at that time was much easier to use than IBM. He says an Apple could do far fewer things. Given there were fewer options and choices, they could make it simpler. It had less capability and therefore was an easier machine to use. Before someone who was not computer literate, if you will, if it was a much easier machine to operate than an IBM at the time, is that right? I can't say the only other. Ms. Abramson says, may I ask that the witness keep the microphone? The court says, put it a little closer to your mouth. Ms. Towery says, now there's something called DOS that an IBM computer uses to make itself run. Yes. What does DOS stand for? Disk Operating System. Without DOS in an IBM computer, it won't run, will it? No, ma'am. Now, this particular computer let me go back to DOS for a second. DOS has a number of different commands included in that program, does it not? Yes, ma'am. And those commands can be used to make the computer do a number of different things, can they? Can't they? Yes, ma'am. Now, the computer that you saw at the Menendez home on August 31st, 1989, when you turned on that computer, it put you into a screen where you had what's called a C prompt, didn't it? I believe so. Yes, ma'am. So a C prompt looks something like that, doesn't it? Let me get my notes and make sure I drew it right. Is that what a C prompt looks like? It looks or might not have the backslash. So I don't know what she's doing. She's writing prompts, writing computer language on the chart, the board that she's using as a visual aid. And he says that, yeah, it looks like that. She goes, uh-huh. In default, it will not have a backslash. You need to actually put a command in one of the starter files. Ms. Nahara says, I'm going to object and make a motion to strike as irrelevant, no foundation as to what the computer is or was. The court says, well, if we can focus perhaps on his recollection of this computer rather than just the general concepts of how DOS language works. Ms. Towery says, what I'd like to do is show what a directory looks like, if I could, since that was his testimony. The court says, right. Ms. Towery says, you indicated to me earlier in the hall when we first met today that your recollection was that when you turned this computer on, you got a C prompt. Isn't that right? That's correct. And that's on a black screen, and there's a C and nothing else. Is that right? Yes, ma'am. And when you are in a DOS screen, basically, then you are in a DOS screen, basically. Is that right? Yes, ma'am. And you can't recall today whether or not there was a backslash. Is that what you're saying? Exactly. Do you want me to take it out? Got lots of paper. No, we can stick with this. Oh, all right. Let's say that you want to see what's in the computer. You have the screen and you see the C prompt and nothing else. You just have a black screen. Yes, ma'am. And you want to know what's in the computer. What would you do? Ms. Nahara says, I'm going to object as irrelevant unless it it is as to this computer. The court says, well, that's the focus is on this particular type of computer, the IBM XT. So objection overruled. If you want to see the directory, for example, simply you would type dir, which is a command for directory. And then what? Add carriage return. So hit enter? Yeah. And that cause the computer to do and what would that cause the computer to do if you did that command? It would cause the computer to show a list of all files that were in the current subdirectory or the current directory, along with the file size of each file and the date, the timestamp, and the file itself. Okay, and you did that on the computer that you looked at the Menendez home, didn't you? You typed dir and pushed enter so you could see what was on there. Yes, ma'am. And you got a directory, didn't you? Yes, ma'am. All right, now let's just talk about a subdirectory. You just mentioned that. Let's say you've got a subdirectory in the computer called, say, DOS, DOS. If you write dir and hit enter, it will show you all the directories under the category, won't it? Yes, ma'am. So what is a subdirectory? A subdirectory is essentially a separate page of the index of the directory where you can group files that belong to each other, that belong with each other. The purpose of the directory is to make it easier to find files. You don't have thousands in one place, you can create sublists. So they're kind of like a drawer inside a file folder. Is that right? Yes, ma'am. So a subdirectory would look something like this on the screen, would it not? Wouldn't it indicate that it's a directory in that fashion? When you printed a directory, that's what would appear. And by print, when you do this and hit enter, you're printing printing to the screen, aren't you? Yes, ma'am. So you're not actually printing to a printer. And that's what you mean by print. Yes, ma'am. So let's say you have a directory called DOS. It would look on the screen, it would show you the name, and it would tell you it's a directory like this, wouldn't it? Yes, ma'am. And then I think you said it would tell you a date and the time for the directory. Yes, ma'am. So let's just put now, in addition to having subdirectories in whatever directory that you're in, you can also have files under there, can you not? Yes, ma'am. And the file is what you were just describing to the jury, is that right? Yes, ma'am. And to make it a little more simple, that I can understand what you said, let's say you have something that you typed as a letter. Yes, ma'am. And you call it letter. A file, when you type this directory and hit enter and see something show on the screen, looks a little different from a subdirectory, doesn't it? Yes, ma'am. And the file won't show dir with these things around it. Correct. Okay, but it will show how big it is, won't it? Yes, ma'am. So it tells you how many bytes. Yes, ma'am. And that's what you were just describing. Thank you for walking us through that because the prosecution didn't want to take the time to do that and it made more sense now what he was talking about with the directory and the bytes and it only has so many characters. And now we know what he was looking at. All right. So he's on that command page when you're in the computer stuff, doing admin stuff. All right. So he says, yes, ma'am. And then it would also give a date and time. Yes, ma'am. And you may have another file. Let's say you mentioned format in your direct testimony. That's also a file, isn't it? Yes, ma'am. But it's a different kind of file than the letter, isn't it? Isn't that right? Yes, ma'am. So how is that format different from a letter? Ms. Nahara says, I'm going to object, Your Honor, as irrelevant. The court says, overruled. The witness answers. Format is an executable program. Ms. Towery says, now that's a real DOS command that I just wrote down there. Format command. Yes, ma'am. And that's something you mentioned either that you did and that is something that you mentioned earlier that you did. Is that right? Yes, ma'am. So this kind of a file will actually perform a function on the computer. Is that right? Yes, ma'am. And this kind of file is something that you create that you want to store some information in. Is that right? Yes, ma'am. Now, how do you use this format file that does something? The same way that you would type dir enter as a command on the first line when you have a C prompt or whatever your prompt. You would type in format space and then a series of other letters, which are parameters to tell the format command how to operate, which disk it should be, or which disk it should format, whether you wanted to write DOS to it, whether you wanted to label it, to name the disk. There's various other commands, little parameters that you can attach. Okay. How did you use this? You used this command to erase the disk, didn't you? The DOS command format. No, ma'am. Oh, you didn't. I'm sorry. I misunderstood you. Can you use the command to erase a hard disk? Objection, irrelevant, overruled. Yes and no. Let me ask you one more question and then I'll ask you why yes or no. This command format is part of what is known as the DOS software, correct? Yes, ma'am. And that's in every IBM or it won't turn on. Is that right? Yes, ma'am. So presumably this command was in the computer that you were working on since it turned on. Isn't that right? Yes, ma'am. Hmm. Now, tell me why yes and no, you can't use that command to erase the disk. Because if you use the format command to erase the disk, it doesn't actually go out to the disk and erase the data. It merely goes to the file allocation table, to one of the maps that tells the computer how to use the disk and wipes out that table. So theoretically, I can take an unformat command or a special program or utility and go and restore that table, or I could use a low level disk editor, which is one of the things that I used, and actually could look at the individual spots on the disk and ignore whether or not it's a DOS disk, ignore the format, and just look at it all. So that takes out the control information, but doesn't necessarily take out the information on the disk. All right. So what you're saying is that you can use the command to make it appear that all the information on the disk is gone, but someone who knows how to operate a computer, who's an expert in the computer, would begin it or would bring it back. Is that right? Right. And if you wanted to, or you made a terrible mistake and hit format command and C, you could erase your whole hard drive. Isn't that right? Or you could believe that you erased your whole hard drive. And you may have, in fact, erased it, but it's not surefire way to do it. But it is present and it is something that people do in erasing their hard drive. Is that right? Yes, ma'am. Now you said that you typed dir, isn't that right? The first thing you did was type dir and hit enter and see what was on that computer. Yes, ma'am. I just had a thought. What if there was or what if Lyle and Erik had reason to believe that there was something on this computer that could implicate Jose and make him look like the monster that he was and reveal the family secret on this computer. What if it wasn't a will at all, because he didn't even have the word will the first time around. So maybe it was just they were looking for files. Maybe they thought there were pictures on the computer. I mean, back then it wasn't as easy to upload photos and stuff, and whatever. Maybe they had the technology to scan and whatnot. I don't know what their technology was, what Jose's financial capabilities what his finances could afford him technological wise. So I mean, this computer's old, but maybe they had other technology somewhere that where they could, like, because they what I'm saying is, all the photos that they found in Kitty's possession of the boys, like full nudity, I wonder if maybe they were worried that something like that was on the computer or something relating to the topic of the essay and CA might have been on the computer, and maybe that's what Lyle was trying to get at or erase or whatever. You know what I'm saying? And maybe there's a perfectly good explanation and we just don't know it. But that just came to my mind. Maybe they were trying to protect the family secret and not destroy a new will, as the prosecution says. Anyways, and when you looked in the hard drive of the computer and saw it come up on the screen, you saw those 4 files that you were looking for, correct? I don't recall which directory I saw them in, but I did see them. But somewhere in a directory that you were looking at, you saw files named Will, Erik, Lyle, and Menendez. Isn't that right? I don't believe I found one called Menendez, but I believe I found the other 3 names. I don't believe there was one called Menendez. But there may have been, and I may not recall exactly. So do you remember testifying at the previous trial that you did find all 4 files? I may have. I don't remember exactly which file names it may have been all, it may have been 3. So now you don't remember. And it may have been all 4. It's unfortunately been a long time. So you don't know and you've changed your answer. Got it. Okay. So could it have been 3? Could have been 4. Could have been 3, could have been 4. Right. In any event, you found at least one of or some of the files. Yes, ma'am, that you were searching for. If you wanted to delete a file on a computer other than formatting the disk that we talked about using that format command, you can type a command in DOS when you have the C prompt and tell it to delete a file, can't you? Or any prompt for whatever subdirectory. Yes, ma'am. And just so let me do this. Let's say you're in the directory, you go to the DOS directory, that directory would look like that's what your screen would look like, correct? And you'd know you were in that, possibly. That's supposed to be a D. It might also just say C colon, unless by default it would just say C colon. You have to tell it to tell you the subdirectories. So you have to look to see what files are in there to see if you're, sorry, let me restart that. So you have to look to see what files are in there to see if they're in a different directory unless you told it to prompt you that you're in a subdirectory. Is that right? Exactly. Now, if you see a file, if you made a mistake and created a file that you don't like, you can give it a command. Give the computer a command to delete it, can't you? Yes, ma'am. And that's very simple. You type DEL space and the name of the file, correct? Yes, ma'am. And it will be gone. Is that right? It will no longer appear on the directory, but the information that had been in the file will still be on the disk. All right. Now, most people who know how to use a computer are not aware of the fact of that fact. Is that a fair statement in your experience as an expert? Ms. Nahara says, objection calls for speculation, overruled. I'm not sure. Again, he's not an expert. So to allow this line of questioning and to not, I mean, he hasn't been admitted as an expert. He probably could be an expert, but he hasn't been admitted. But she's using him as an expert to get her testimony across, which I don't hate because I'm here for the defense, but I just don't know why it's allowed. Ms. Tari says, okay, most people use some sort of a delete command to get rid of files that they don't like or they don't want anymore or they made a mistake on. Isn't that right? Objection assumes a fact, not an evidence. Most people do. And the court says would call for speculation. Whoa, sorry, trying to readjust my mic here. All right, so Ms. Towery continues, is that a common way to make a file go away to erase a file? Ms. Nahara says, I'm going to object as irrelevant. The court says he's already answered the file that you can delete a file in this fashion, and it will still be there, but not in the directory. Ms. Towery says, and when you mean that it will still be there, but not in the directory, you mean that the average person, when they type dir and enter and look through a computer, cannot see the file anymore. Is that right? So they didn't actually delete anything or damage any files on the computer. All they did was change the directory, the way that the directory displayed or appeared to people. So he says correct. And you have to have a certain amount of expertise to find it in the hard drive. Isn't that right? Correct. And you have that expertise and have a program that actually permits you to do that. You can look through the hard drive and find files that have been deleted in that fashion. Isn't that right? Yes, ma'am. And you ran that program when you went through the computer at the Menendez house, didn't you? Yes, ma'am. And you didn't find any deleted files with the words that you were searching for in them, did you? Not with those titles. So even before he messed with the directory, before he altered the directory or the appearance of the directory, um, he ran this program on the computer to see if any files had been deleted, and he said they had not for those titles that he was looking for. Okay, you were asked to look for 4 words, correct? Correct. And you didn't find those 4 words when you searched the entire hard disk in the deleted files that had no names. Isn't that right? Correct. And before you used that program to search through the hard disk, this was after you had already pulled up the files that you did locate. You told Lyle Menendez that you were going to go through and search for the entire disk for any deleted files, didn't you? Yes, ma'am. Now let's talk about the files that you did find in the computer. You said that I think you mentioned that they were dump files. Is that right? Yes, ma'am. And what do you mean when you say a dump file? Just using it as a colloquial expression for a file without any real relevant or intelligent or intelligible information, that it wasn't a letter, it wasn't a spreadsheet, it wasn't a program, that in fact, what it appeared to be was merely a printout or a copy of a directory similar to what you've drawn here. Okay, so when you looked in the file, let's say the file that was labeled Will, what you saw was something like this. Is that right? Yes, ma'am. So the content of that file, instead of having information like a letter or something like that, had these types, exactly what you saw on the screen when you're looking on the computer and what we've drawn here. Is that right? So basically, he's only seeing the directory. Yes, ma'am. And what was true of each of the files that you looked at, and that was true of each of the files that you looked at, isn't that correct? Yes, ma'am. All 3 or perhaps 4 of the files that you looked at had a directory listing inside the file. Is that correct? Yes, ma'am. Let me do this. Can I mark this, Your Honor, next in order? He says 112. Ms. Abramson says, do you want to take that off? Ms. Towery, world's largest post-it. Ms. Towery Ms. Towery says, and Your Honor, I'm going to make another little chart here that I'd asked to mark as 113. The court says, all right, yes. Ms. Towery says, do you remember if you found a directory called Menendez in the computer? I honestly don't recall. Do you remember testifying previously that you thought that you had? Oh, I believe. I don't recall. Okay, would looking at your prior testimony again refresh your recollection? It would refresh my recollection as to what I said, but at this point I don't recall exactly. Okay, so I mean, I wouldn't be surprised, but I don't recall. Let me ask you a couple of questions. Let's say you're in a directory and it is called Menendez, whether or not you saw one or not, and you're searching for some documents. And you indicated earlier that if you wanted to show a directory, you would type dir, correct? Yes. And you also indicated that if the computer was programmed to show the directory that you're in, it'll say the name of the directory, right? Yes, ma'am. If it's not programmed, it will just show you the C prompt. Is that right? As the prompt, yes. Okay, now, what if you want to see a directory called Menendez? How would you go about telling the computer if you had this? What to see is just that, what to see is just, if you had this, what to see is just the C. How are you going to tell it that you want to see the Menendez subdirectory? That was a really confusing question. Objection is irrelevant, overruled. Two ways come to mind immediately. One is Ms. Abramson says, "Can I ask the witness to speak into the microphone?" The witness says, "Sorry." Ms. Abramson says, "Thank you." The witness says, one is you can type dir space either backslash Menendez, or you're already in backslash and you can type dir space Menendez. Or alternatively, you could type C/D, which means change directory, return, and then just type dir. So rather than having to refer to the directory, move into the directory, and then just type dir. What? But okay. Ms. Tari says, so there's several ways that you can get yourself into a or look at what's in a subdirectory in the computer. Yes, ma'am. And that's one of those drawers that you put things in. Is that right? Yes, ma'am. So let's say that, and one of the ways type to type dir space and then the name of the directory that you're looking for, correct? Yes. Now, let's say that you are not very good at working IBM computers back in 1989. What if you see this prompt and you type dir and one of these little things that shows on a directory when you're seeing a listing of the directory and the name of the directory that you want? Ms. Abramson says, could counsel describe this little thing as a particular? Ms. Towery says, what is the little thing that I just drew? He says, I would call it a greater than sign. Thank you for putting that on the record. What does it mean in computer language? In computer language, at least this part is an output sign. An output sign that looks like a greater than sign? Right. If you're in a directory and you type that, what will happen? It will run the directory command as we've been speaking about, but rather than sending the information to the screen, the greater than sign or the output sign says write the information to a file. So it will either, if no such file as Menendez exists, it will create a file called Menendez, which will contain text which looks exactly like what you would have seen on your screen. And if this were a file called Menendez, it would erase that file or write over the file with a new file that creates that has the information on the directory screen. Okay, so let's say that you have this on your screen. That's what you're looking at. You've asked to look at a directory and you see this on your screen, and then you have your prompt again to tell it to do something else if you type this. If you type this, what's going to happen if there's no file with this name in that directory? You're going to make one, aren't you? Yes, ma'am. And what will be in that file is this, what was on the screen. Isn't that right? Yes, ma'am. So if somebody so somebody else already searched for a file named Menendez, is what they're saying, and it created the file Menendez, but there's nothing in it. And so it's very possible that whoever looked on the computer prior to Howard Witkin, who was searching for a Menendez file or a Lyle file or an Erik file, all of those files were created because of that search in the directory, is what he's saying, is what I'm taking from that, even though some of this is really complicated and I don't understand his explanations, which is why he shouldn't be admitted as an expert in technical stuff unless he dumbs it down for the rest of the jury and for us reading it along at home. All right, so next question. But when you type that, it's not going to say, I made a file, is it, the computer? I don't recall if it will say one file copied and that command or not. I don't. Do you want to try it on my computer and see? No, you can test it for me. I don't recall. And it's changed from, I don't think it will, but it might, to the best of your knowledge. I don't think it'll say anything. It doesn't say anything. It just gives you another prompt to that so that you can do something else. Isn't that right? I'm pretty positive. Okay, and let's say you typed this in and nothing happens. Right. So you type in another word that you're looking for. Again, you don't know that what you're doing and hit enter. It'll do the same thing. Make another file that's called Erik that I just wrote down. That has the information on the computer screen in it, right? Yes, but it should at that point also have Menendez in it because you've just created a file called Menendez. So it should be the same thing, but one more file. One more, okay. And that's true as long as you keep going down the list. Whatever you're typing, you're making files. Isn't that right? Correct. And similarly, if there's already a file in the directory that you are in and you type, if there's already a file named Menendez, it will create the information on the screen over the top of the file. In other words, replace it. Correct. With the information on the screen, right? Correct. And the same is true with the file named Will and the file named Lyle. Correct. So any of those files which contain the type of information that you saw on the computer could be created in that fashion. Isn't that right? Correct. And in fact, what you did see was either 3 or 4 files that contained just a directory and nothing else. Isn't that right? Yes, ma'am. I think we figured out how those files got on the computer. I think Lyle's team did an excellent job of showing us how those files got there just now. But was this as much of a bomb drop or mic drop for the jury as it is for me? Because I think it's clear that that means that those files were probably not already on the computer and somebody accidentally created them while looking for them, if that makes sense. The court says, do you remember what the directory was in the file? The witness says, to the best of my recollection, it was a short directory with just 3 or 4 files, but I believe each of them were identical. I don't believe any more the exact contents of them. So if they were identical and had, similar byte sizes and all that, it would suggest that they were all created similarly. The court says, do you remember the names of the files? The witness says, that were in the lists? Yes, I don't recall. Were they the same as the directory of the files that you're looking for or different? The witness says, I think they were the same, but I don't recall exactly. Okay. Now the witness continues, I vaguely remember remembering that they were the same, but I don't remember strongly enough to say for certain. I like remembering. Ms. Towery says, also, back to the time element, you mentioned that on an XT computer, the time that we showed on the directory listing doesn't really mean anything because of the lack of the ongoing clock, right? The absolute time doesn't matter, but relative time might. And by relative time, you mean how far apart, say, files are directed. Is that right? Exactly. So if one file was made and 2 minutes later another file was made and 2 minutes later another file was made, you can see that it was all, done one right after another. So if you make a file and you look at it on a directory, it will show you how big it is and the date and the time that it was made, and that then the next file that's underneath it will have the same information, correct? Right. So to your recollection, when you looked at the 3 or 4 files that you located on the computer, they were either created or changed all within a very short time period. Is that right? Correct. So within a minute or two of each other? Yes, ma'am. Bingo. And that's what I just said. So if they were done right in, one right after another, it seems like Lyle's defense team solved it. So that is something that you did notice because that did mean something to you. Correct. The relative time to each other. Correct. But there was no way that you could tell that the time that the files themselves were made. Isn't that right? Correct. So now these files that you did see on the computer when you looked through it, you cannot tell whether or not a file in a computer is created on purpose or created by accident. Isn't that right? I mean, you generally assume that anything that was created by a conscious act. I'm not talking about by a conscious act as opposed to lightning struck the computer and made the files. You don't know whether the person who made those files, who hit the keys on the computer, knew that they were making files or not. Isn't that right? That's true. And people do make files accidentally. In your experience, do they not? Yes, ma'am. As well as deleting them accidentally. Isn't that right? Yes, ma'am. As well as copying over them accidentally. Isn't that right? Yes, ma'am. And particularly when people are trying to type in DOS, the mistakes are amplified because of the difficulty in using the DOS program. Isn't that right? Yes, ma'am. So Windows wasn't around back in 1989, or at least it wasn't on this computer, was it? Correct. And you again used several of your own programs to search the rest of the disks, since this is what you found on those 3 or 4 files that you located. You searched the rest of the disk with several of your programs to try and locate those words anywhere else. Isn't that right? Correct. And you didn't find them. No, ma'am, I did not. Now, after you located the files with the directories in each of them, and after you searched the whole disk to see if you found anything else, you told Lyle Menendez that you had done this and told him that you had found what you had found. Is that right? Correct. And it was after you told him that he asked you to delete the information on the computer, isn't that right? Correct. And that's when he told you that the information was confidential and that they would be selling the computer and that he did not want confidential information being disseminated to other people. Isn't that right? This again makes me think he thought maybe there might have been something possibly incriminating for Jose and Kitty, incriminating their perpetrating of SA on their own children and CA on their own children. So this makes me think that he was trying to protect their image. Correct. And also, had told you that he was in a hurry because he had a plane to catch earlier when you talked to him on the car phone, didn't he, Lyle? Yes. And when you did erase all of the information on the computer, you also erased these 4 files with just the directory information in it, didn't you? Everything. So you didn't put that back, did you? No. You just put back on the software you described. Is that right? Correct. And even though you erased a disk and put the software back on, still it's possible to tell that the disk had been erased. Isn't that right? Yes, ma'am. So he wasn't like he wasn't really hiding everything like he could have. He was just up altering the directory. All right, and you could have told, had you gone in and looked at the disk, or you could have, didn't I read that one already? Okay. So for an expert, it's not very hard to do. Is that right? Yes, ma'am. For a good expert. When you put the software back on, you indicated that in your direct testimony that if the disk were empty, it would have looked erased. So you put the software back that were in the original back on. Is that correct? Correct. The spreadsheet, I think you said you reinstalled DOS. Is that correct? Correct. And if you don't reinstall DOS again on the computer, it won't turn on, will it? Unless you have a floppy disk. An old IBM XT, it would boot back to something called ROM Basic, which is basically useless. But it wouldn't work properly without DOS, would it? No. So people would know that there's something dreadfully wrong in the computer if you didn't put it back on. The court says, how much longer are you going to be? Ms. Towery says, just a few minutes. The court says, is there examination by Erik? Ms. Abramson says, it would be helpful if I consult with Ms. Towery. The court says, we'll take a recess and resume at about 5 minutes to the hour, 5 minutes to. The following proceedings were held in open court outside the presence of the jury. We've got some arguments here. And I lied. It's not it's not they're not going to have oral arguments. It's just the court saying the trial, we have everybody back. President will resume. Mr. Witkin indicates that he has some time problems. So we'd ask that counsel expedite this so he can be let go as soon as possible here. Let's get the jury out. The jury entered the courtroom and the following proceedings were held. The court says the jury is back. You may continue your cross-examination. Ms. Towery says, "Thank you, Your Honor." Mr. Witkin, I want to add, blah, 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 blah. Start over. Mr. Witkin, I just want to clarify a couple of things that you talked about in terms of the chart that I drew. Now, when you talked about typing DIR and the greater than sign and the name of a file, and when you would do that command, you would create a file in the computer, correct? Correct. Sorry, the dogs are all walking around. I don't know if you can hear them. They're being pests. All right. Hopefully they settle down. All right. So where do you find the greater than sign? Is that on the keyboard? Yes, ma'am. So it's just a key you punch, just like the letters, like a typewriter. Is that right? Correct. And after, just like a typewriter, that's what she uses to reference because more people are familiar with typewriters than they are with computers at this time. So that's kind of telling you where we were with technology at the moment. All right, so after you typed this, you would push enter on the computer. Is that right? Correct. And that again, you call the return. Is that correct? Correct. And again, like a typewriter, it's the key that you punch to make the carriage go back. Correct. In computer language, it would be a similar key. Is that right? Yes. So what would happen if someone typed this and pushed the enter key? Again, you would get the C prompt, but you would not see that a file had actually been created. Isn't that right? Correct. Now, the only difference between doing a search for a file of that name and making a file of that name is if you push the little greater than key in between them. Isn't that right? Correct. If you do the search, it will show you on the screen what you're looking for. And if you push the greater than key, it will make that file. Isn't that right? Correct. So you could have easily accidentally made these files. If you didn't know what you were doing and looking in the computer for these names, you could have easily made them. And that's what she is pointing out, and she's doing an excellent job. Now, also, when you got into the Menendez computer, when you turned it on, there wasn't any sort of logon sign or anything like that you had to type in, was there? No. No passwords or anything like that? No, ma'am. So if someone were to make these files by entering these letters on the keyboard, you couldn't tell who did it. Is that right? Correct. And you couldn't tell when it was done because of the time? Correct. And once you typed these, the command and the name of the file, and then hit enter, that file is made immediately. Yes, ma'am. Okay, so you hit enter and then you just see the C prompt again and a couple seconds of. So someone could create all of these files by typing in these entries without realizing they're doing it. Isn't that right? If they didn't know what they were doing. Correct. It's powerful. Or they made a mistake in searching. Isn't that right? Correct. So if that was done, if someone was searching for those four files and entering that command dir, the greater than sign, and typing the name of the file and hitting enter sequentially, what would be happening, and they wouldn't see it, would be files would be created that would be in the directory, but you wouldn't know it. Is that right? Correct. So they are inadvertently during the original search of these files, they inadvertently, accidentally put in the greater than sign, which changes the code completely and created files of those names. So instead of looking for them, they actually created them. that makes sense. Well, they looked for them, and since the computer said there are no files of those names, and he typed the greater than, it created the files. If someone then, either later or even that same person, just typed the words that we talked about at the beginning, DIR, and hit enter, they'd see those files. Is that right? Correct. Ms. Abramson says Ms. Towery, and then they converse, and then Ms. Towery says, so in essence, if a person typed in that command dir greater than and the name of the file, they would have made the file that they were looking for. Is that right? If they were searching for that file. Correct. So they created the file. That's what I've been saying. And that's some good detective work on the attorney's part to, I'm sure they don't have the experience and knowledge, in computers, so they had to consult their experts and find out that this is how you would do it, and this could have easily been a mistake. And so good part on that, or good on them for finding that. Now, you mentioned that your recollection was refreshed after looking at the receipt that you prepared for Lyle Menendez at the time that you did this service for the computer, and that you now recall that you did show it to him. Is that right? Correct. When you put the receipt down, you didn't try to hide it, did you? No. You just sat it down in plain view. He had walked out of the room before I finished with everything, when I tore it off to separate it, so I just set it down. Okay, and you sat it down in a place where it could be seen. Yeah, yes. And Lyle Menendez never indicated to you that the services that you performed were to be kept confidential, did he? No, not that I recall. No. And he never indicated to you that he didn't want any paperwork regarding the transaction, did he? No, not directly. And he also never indicated to you, not directly? He never said, burn your paperwork or do anything, but he said no separate invoice was necessary, that normally we do a service authorization and a follow-up invoice. And he said a receipt was sufficient? Yeah, that the document was sufficient. But the receipt indicated the nature of the services, did it not? Yes, ma'am. And he never indicated to you that he knew how to operate a computer, did he? Not that I recall. And the check that he gave you had the name Menendez on it, did it not? Yes, ma'am. And it bounced, didn't it? It was returned by the bank. Okay, you didn't collect on it. You got the bad check, didn't you? Got the check back. Oh, got the check back, didn't you? Got the check back, yes. And you were the one who ultimately turned it over to the police, correct? Correct. Ms. Towery says, may I have just a moment, Your Honor? Ms. Towery says, I have nothing further. Thank you, sir. The court says, any questions on behalf of Erik Menendez? Ms. Abramson says, no, Your Honor. So no questions by Erik's counsel, and that is fine because I think Ms. Towery did an excellent job of demonstrating what probably is more likely what happened. So Ms. Nahara says, thank you, Your Honor. Redirect. All right, so we've got some redirect examination by Ms. Nahara. Very briefly, sir, the result of typing in, if I may, all of the commands that Ms. Towery asked you about, and basically what all that you have told us about these computers and these commands, what it all does down to is the result of typing in these commands is that you can do one of three things. Is that right? One of a number of things. And did you tell me of three things that basically this would result in? Yes, ma'am. And would that be to create a file with a directory? It would result in either creating a file with a directory, writing over a file, or an attempt to get a directory. That is right? Correct. And if it were an attempt to get a directory, would the result of typing these commands in be that you might enter intentionally or accidentally create a new file? Yes. And could you also intentionally or accidentally copy over a file? Yes. And was there any way to tell from the information that you got there whether or not someone had intentionally, well, first of all, if anyone had intentionally copied over a file? No way to tell. Could you tell if someone had accidentally copied over a file? No way to tell. Could you tell if someone had intentionally or accidentally created a new file? No way to tell. And is that what all of this information that you have testified concerning commands that would be is the end result? Is that right? Correct. Regardless of the results of the commands, did the defendant, Lyle Menendez, ask you to find a file in the computer labeled will? Yes. And, well, how do you know? You don't remember. So how can he testify to that assuredly? He can't. And when you couldn't find this file, you said that he was happy. Now, she's just testifying. Now, is it your experience, your common experience, when you go out to retrieve files? People, Ms. Towery says, objection beyond the scope. Ms. Towery says, ask you to retrieve and by Ms. Towery. No, the question is by Ms. Yeah. There's so many what's the word? Errors in these transcripts by Ms. Oh my God, I'm blanking on her name. Why am I blanking on her name? What is the prosecutor's name? Ms. Nahara. Oh my gosh. I cannot remember. No way to tell. No way to tell. Okay, so objection beyond the scope. Ms. Nahara says, ask you to retrieve and you can't find any. Are they happy or upset? Ms. Towery says, objection beyond the scope and it's irrelevant. The court says it calls for speculation on behalf of the witness. Sustained. Ms. Nahara says, commonly when people ask you to come and retrieve files that are lost, do they call you out there because they want to find those files? Objection irrelevant beyond the scope. Sustained. Calls for speculation. Sustained. Ms. Nahara says, when you go to retrieve files, are people usually happy that you can't find the files that called you in to retrieve? Objection irrelevant. The question already has been asked. The question has been sustained. Ms. Nahara says, the defendant, Lyle Menendez, after you told him that, he asked you to erase all of the information in the computer. Is that right? Ms. Abramson says, asked and answered, Your Honor, and beyond the scope. Overruled, overruled. Yes, says the witness. Ms. Nahara says, did he ask you, after you had erased all the information, to make it look like you had never been there and you had never done that? Yes, ma'am. Ms. Abramson says, asked and answered, improper, redirect. The court says, overruled, the answer will stand. Ms. Nahara says, I have nothing further. The court says, anything else? Ms. Abramson says, no, Your Honor. Ms. Towery says, no, Your Honor. The court says, thank you, sir. You may step down and you're excused. Ms. Towery says, oh, I did. I would ask that the third chart that I marked be labeled for identification as next in order. The court says, okay, 114. Anything else? Any other witnesses at this time? I assume not since it's 420. So let me see counsel at the side without the reporter for a scheduling session. The following proceedings were resumed in open court. So they did some scheduling and now here's some arguments. Or scheduling. Hold on. Yeah, it's just scheduling. And the court says, okay, Monday will start up again at 8:30. There was a request by juror number 1311 that was for the 27th, as I recall, not the 25th, at 3:45, unless you're changing it. Juror number 2, no, Your Honor, 1313. I have a doctor's appointment on the 27th. The court says, that's the only one I have. I have one. I thought the one I had was for the 13th. I don't know which number. I don't have it in front of me, but it was for the 27th at 3:45. You wanted to leave. The juror says, that's correct, Your Honor. The court says, and now we have another one that I just received. This is for the 25th, which is Wednesday. And what time did you have to leave? Juror number 7 says the appointment at 2:05 but I'll try to get it later. I'll know Monday. The court says if you could do it later, that would be fine. The later in the afternoon, the better, so we can get more on more of the afternoon session. Juror number 7 says, I'll know tonight. The court says, okay, we'll talk on Monday then. Just a reminder then, we'll start on Monday at 8:30. It's very important to not talk about this case with anyone that you not form any final opinions about it, and that you not look at any of the news coverage or read any of the news coverage or listen to anything about the case in any form whatsoever. Again, your decision has to be made on only what you see is presented to you right here in the courtroom. And just to respond to the one request we'll be breaking at 3:45 next Friday, the 27th, to accommodate one juror's appointment. Juror number 2 says, thank you, Your Honor. The court says, and then we'll find out more on your other appointment on Tuesday, and we'll hopefully, if it's later in the day, it will be better for us, but you let me know on Monday. We'll see you all back here on Monday. Have a good weekend. The jury leaves. The court says, okay, while we're waiting for the jury to leave, was there something counsel wanted to discuss? Ms. Abramson says, well, Judge, you recall you were going to review the questionnaire with respect to number 6. The court says, I'll get to that on Monday. Ms. Abramson says there were 2 things. I want to alert the court to a scheduling involving myself. I'm going to be requesting that the court, if it won't recess, at least allow me to leave by 2:30 on December 1st, which is a Friday. I have to be in Portland, Oregon that night. And I would obviously prefer, if I think I can, the last plane I can get to get me there on time is at 3:30 from Burbank and Alaska Airlines. So I guess I could even go as late as 2:30, but I would like to have that 2 hours early off so I can make that appointment before then. The court says, okay. If you could perhaps, as we approach that time, maybe there's some hearing or some issues that can be dealt with without your presence if we're still in session and doing other matters that we can work on. Ms. Abramson says, perhaps we can do that. That would be fine. I would hate to it happened in the last trial because of a tragedy in my family that I actually wasn't here for a couple of days when testimony went on, and it was a very uncomfortable, peculiar situation for me. Although the real problem was we were putting on defense witnesses who couldn't wait around, so it was really the defense's need to do that. The court says, well, we'll be in the defense at that stage. Ms. Amerson says, we'll be in the defense part at that stage, and there may be some hearing that Mr. Levin can handle so that the jury doesn't suddenly see me exit stage left. The court says, well, just keep that in mind as what my preference is, and we will be able to use that time for something. Ms. Amerson says, okay, Judge, we'll keep that in mind. The court says, anything else now? Ms. Amerson says, we did get a declaration, I think. I don't want to get into the whole discussion about it, but I don't know if it has been filed in the with the court. Ms. Nahara says, yes. Ms. Abramson says there is a declaration from Roger McCarthy, and I'd like the court to look at it and see if it satisfies our concerns and the court's thinking about the diagrams. But now I've been told by Ms. Nahara that Dr. McCarthy has refined what oh, hold on, my dog's coming inside from being laying in the sun. Sorry. We're finally getting nice weather, and the dog won't come in. If I call her, she just looks at me. So she stays out and decides she's just gonna sunbathe. And I leave the door like semi pushed in, but not all the way, so because she'll push on it and come in at her own time. So then I have to go close the door when she does that. She really needs a doggy door. Anyways, all right. So, continuing on, Ms. Abramson says, but now I've been told by Ms. Nahara that Dr. McCarthy has refined what are now being called the illustrations, and we'll get a version of, and I don't know what they are, they're refined illustrations. When are we going to get these? Monday? Ms. Nahara says, there should be a hard copy for you downtown in your office right now. Ms. Amerson says, I don't have an office downtown, but downtown in the public defender's office. So I'll get it over the weekend, and Monday we're supposed to get a CD-ROM with the refined illustrations. Ms. Nahara says, that's tentative, we're hoping. Tentative. Now, what we need to do, says Ms. Abramson, whenever we get anything from from Dr. McCarthy, at this point is duplicate everything and send it out to 4 other people all over the country. So if my experts now have to start back with this new set of illustrations, I just let the court know that all of this takes time to get other people up to speed. Roger McCarthy may now or may know what's in his head, but the communication loop is about a week long. The court says, all right, well, as soon as you get more information, let me know. And looking at that declaration, it does seem to conform with my recollection of what he was saying, that these are merely illustrative of his testimony and not generated by the computer, which magically created the scene and the various shots. Okay, fine. The court says, all right, Mr. Khan says, I would also like to indicate for the record just what the changes consist of in the illustrations. There's really no much difference to the illustrations. That is, that the court ruled that he put the measurements of certain items into the illustrations. One thing that he didn't have was the measurements for the furniture. The furniture was just depicted. The illustration of the furniture was just based upon their visual images and they appear in the photographs. Well, we provided him with a copy of the measurements taken by the Beverly Hills Police Department when they were at the crime scene, which he didn't have. So he made those. He entered that data into the illustrations, and so the furniture is simply drawn more accurately. That's all it is, just a simple change. But actually, there's no visual distinction. It's not even noticeable. I just want to let counsel know that that change has been made, even though it's not visually detectable. So then why are you doing it? Just so she wouldn't be surprised by the change in the information. Ms. Abramson says, might I inquire if Mr. Khan is referring to the measurements by the Beverly Hills Police Department, meaning the hand-drawn diagram that Detective Zoller came up with, or is there something else? Oh, that was a funny question. Like, she's totally sassing right back. All right, Mr. Khan says, as part of the old discovery, there were measurements of the table and sofa and so forth. So nothing new. Right. He just incorporated those measurements and made the furniture more accurately drawn, and I think he numbered them 1 through 12 and A and B. So there's really no changes to the substance of the illustrations. Other than that, we have one witness to be ordered back for Monday, Mr. Eslamania. Mr. Eslamania, would you stand, please? Mr. Eslamania says, certainly. The court says, okay, what time do you want him back? Mr. Khan says, well, if the court wishes to proceed with one more witness, we can. The court says, make it 10:30. All right. You're ordered to return at 10:30 Monday morning. Anything else counsel want to discuss? Mr. Khan says, yes, there's one additional thing. Mr. Khan says, we noted about a week ago that one additional matter that had not been resolved is the admissibility of the defendant's refusal to submit to handwriting exemplars. There was some comment that the court had, in fact, made that ruling, and the court invited us to come up with a citation to the date that the matter was put over, and I think that we found that citation. So all we need now is a ruling from the court concerning the admissibility of that evidence. The court says, okay, my notes conform with basically what transpired. My ruling or response to the people's proffer of evidence at the hearing at page 28069 through 70 was was to defer ruling until it's determined whether or not the defendants concede that the handwriting was that of Erik Menendez, and that's what I said at the time. I don't know what handwriting of Erik Menendez they're talking about. And that is still the situation. If it is not conceded during the defense case, then the people would be prompted to prove this. Ms. Abramson says, I actually did mention it in my opening. The court says, well, opening statements are not evidence. She says, I know. Like, you don't have to tell me, Judge. The court says, so that remains the status, and it would be regarded as improper rebuttal if there was something that occurred during the defense case which results in their not conceding that. Ms. Nahara says, thank you, Your Honor. The court says we'll be in recess until Monday. And that is the end of that. We will continue on Thursday with the testimony of Grant Walker. I didn't do a poll because I was going to combine Grant Walker and Howard Witkin, and then I didn't have time in my recording schedule. So now I'm doing them separately, and we will begin with Grant Walker, who is a pool maintenance repairman. He did testify for the prosecution in the first trial, and I'm going to read through it. And it seems like you guys keep telling me, yes, in all of my polls, anyways, that you want to hear the testimony. So if that is the case, and you don't want me to poll you anymore and you just want me to do all of the like everybody's testimony, I don't care. That's fine. I'll read through all of it if that's what you guys want. So maybe I'll do a poll with this one or a separate poll just asking you guys if you want me to quit polling you because I don't mind doing everybody if that is, how we want to roll going forward. And look, they're arguing about Mr. Eslamania on this Friday, October 20th, and he doesn't even testify until October 27th. So, uh, Eslamania went to high school with Erik, so that's who he is. Anyways, yeah, so I look forward to seeing you guys in the next one. We will go through Grant Walker's testimony. I believe in the first trial, he kind of testified to the brothers like swearing and arguing with the parents or whatever. So that's like he was there performing maintenance or repair work on the pool, and then he happened to witness some, arguing or whatever in the household, which he's like the only person that's ever said that the boys like talked back or, were arguing with the parents because everybody else said that they did not talk back. They knew what happened to them if they talked back. So they did not. They did not talk back, especially in public. We know that when Erik got mad during one of his matches with Jose, because Jose was being like exceptionally, unruly as a tennis parent on the sidelines, being really critical of Erik and his performance, all of a sudden he yelled, "Shut up." In the middle of the game, Jose came, like, Erik lost himself there for a second, said, "Shut up." It's like one of the only times he really stood up to his father. And at that point, his dad left the bleachers, grabbed him off the tennis court, dragged him to the car without saying a word, mind you, and gets him to the car. Erik sits down in the back seat, and Jose punches him right in the face and says, "Don't you ever effing talk to me like that again," and whatever. And that is, you know, those are the stories that we know. Those are the instances that we know of. But yet, this Grant Walker is going to talk about something just the opposite of what everybody basically has told us. So we'll get into that on Thursday. Thank you guys so much for watching. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.